The Bill of Rights, a document which is exactly what it says it is. It lists out the rights given to citizens of the United States by the U.S. government. Today we'll look at two specific amendments, Amendment 4 and Amendment 6. Amendment 4 says, and I quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized." Many cases have been overturned or the accused found not guilty due to this amendment. This amendment says that cops, detectives, FBI agents, or any other governmental law enforcement agency is not allowed to take evidence against a citizen of the United States without a warrant or probable cause. Probable cause can mean many different things and is often hard to prove, such as a woman screaming or a loud crash or bang. Law enforcement also have the opportunity to receive a warrant. When given enough evidence, a judicial court can hand a warrant to an officer, allowing them to search for a specific object or item listed on the warrant. If an object incriminating a citizen is found while searching a resident but is not listed on the warrant, then the officer does not have the authority to arrest or accuse a citizen of any wrongdoing. There's two specific court cases that go with this amendment. There are many, many more, but we'll talk about these two today. The first is Utah versus Strife. This gave cops and government law enforcement agencies the ability to make an arrest even though they stopped someone illegally if the link is too loose to point out. This decision gave more power to the cops when they are searching for specifics on a person who have an outstanding warrant. There was a specific situation where Strife was taken and had a warrant against him, but that was not what they were specifically looking for. They then found incriminating evidence on him for later stuff. This case was based on that specific instance rather than a normal occurrence. So while police do get into these situations, they aren't very common. However, this ruling does provide precedence when it comes to giving more leeway to cops due to the statement of when the cost of its exclusion outweighs the benefits. This statement is very subjective and will ultimately end up in the court's hands. The second court case is entitled Maryland versus King, and this is where a DNA swabbing is considered, or what is a DNA swabbing considered when a citizen is being arrested. DNA swabbing convicted Alonzo J. King Jr. of rape after the DNA was collected when he was arrested. He attempted to get the decision appealed, saying he was not convicted, therefore saying that the police did not have the right to take a DNA swab, but the court ruled saying that the police did have the right to take a swab, saying it was the same as fingerprinting someone who they had just arrested. What it really came down to was, do the police have that right to take that DNA swab? And the court said yes. So then that was Amendment 4, dealing with the right of search and seizure, and then getting arrest warrants and just warrants in general. Then we go on to Amendment 6, and it is, as I quote, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." This is the right usually when someone is getting arrested. Those being tried for a criminal offense will be allowed a jury provided by the state, along with the ability to gather witnesses and have a lawyer defense. A lawyer being that same word in the amendment as defense. This makes sure to allow the accused to not be wrongfully committed by means of backroom decisions, a lack of defense, or even ignorance of the court system and how the court works. This amendment is often quoted or paraphrased by law enforcement officers all across the United States when arresting a citizen. By giving these rights to the accused, the amendment is making sure that no appeals can be made saying a convict was wrongfully sentenced based on an impartial jury, there was no attorney, or a lack of understanding of the way the court works, so there was someone there to defend him, or not allowed having witnesses to provide defense of his standing and what happened during the altercation or whatever. the man is being tried for. There's one last part that we need to address, and that is at the very beginning of the amendment, the right to a speedy and public trial. A speedy trial is in no way a rush trial. It's not trying to get through it as fast as we can. It's instead saying that the court will not initially run a case or intentionally run a case longer than it needs to be in order to take the accused either run out of money or have an accident happen, or there's something comes up where he then gets convicted of said crime. The public trial allows for citizens to go and view, but again, it's another check on the court, making sure that there's no underhand deals being made between the judge and the prosecutor, or even the defense. Everything is public, everything is seen, everything. It's attempt at a complete transparency. There's two specific court cases that I again want to go over, but they're actually very similar, which is very interesting, and they're both in Washington and California, which is cool. So we got Cunningham versus California. John Cunningham was tried, convicted, and condemned to a maximum sentence allowed by California. The decision was not based on whether or not Cunningham was guilty, but on whether or not the judge had the right to impose that sentencing based on evidence not heard by the jury. I'm going to quote the Sixth Amendment by saying, "By an impartial jury of the state and district wherein the crime shall have been committed," is what he was trying to say, that he did not have that jury overgo certain evidence in order for that extended amount of sentencing to be given. While one was provided, there was a jury. The decision for the sentencing was based on evidence not heard or discussed by the jury. It was only by the judge, and then the judge decided to give him an extra long sentencing. The appeal was denied by both the California Court of Appeals and the California Supreme Court according to the California laws and rules. Their rules, as well as what we'll later see in Washington, said that what the judge did was constitutional. However, the Supreme Court accepted this case and eventually ended in a 6-3 vote in favor of Cunningham, saying that that was a violation of his Sixth Amendment right, saying that he didn't have a jury to see the later evidence and provide beyond a shadow of a doubt that he was in fact guilty and in need of a further sentence. The ending arguments for each side talked about the constitutionality of California's laws, which allowed for the judges to give these verdicts, but without a need for a jury to hear certain evidence in order to tack on that extra sentencing. Blakely versus Washington is the second case, which is very similar to that of Cunningham. It is similar in that the case was in a much higher sentence was given when evidence was only reviewed by the judge. Interesting enough, though, the ideological views, when you look at the votes based on where the Supreme Court stands in ideology, they're very close to the same in Cunningham versus California, where both the far right and the far left agreed that it was a violation of the Sixth Amendment to invoke a higher sentence when the judge reviews the facts without the jury, saying that it was against the Sixth Amendment. However, the moderates, the ones in the middle, ideology-wise, those court justices deemed that it was not a violation of the Sixth Amendment, which is very interesting how that works. So we've gone over two different amendments. We've got Amendment 4 and Amendment 6, both talking about, you got one with search and seizure, which is the Fourth Amendment, and then the other about how a criminal does have the right to have an attorney, impartial jury, and different rights that someone who's being prosecuted or has been arrested have these rights as long as they are a U.S. citizen. Interestingly enough, again, Amendment 6 is usually what's being quoted by those law enforcement agencies, or is seen on TV shows, but also usually paraphrased by police themselves. So we've got two that deals with what police can do, as well as what just different rights of different people, citizens, and how it comes into contact with the law. I would highly recommend to look both of these over, as well as there are many Supreme Court cases going with both of them, and how to make sure that you properly understand it, especially if you're going into law enforcement, on how these really do affect you and just how controversy there are. As you can see in a lot of the votes, they were very, very close. But these are two great amendments, really just giving rights to people to make sure that the government does not have too much power or does not wrongfully accuse or invoke sentencing onto someone.